Public Notice by Dan Meeder. This memorandum will be construed to comply with provisions necessary to establish presumed fact. Bracket Rule 301, Federal Rules of Civil Procedure, and attending state rules. Bracket. Should interested parties fail to rebut any given allegation or matter of law addressed herein, the position will be construed as adequate to meet requirements of judicial notice, thus preserving fundamental law. Matters addressed herein, if not rebutted, will be construed to have general application. A true and correct copy of this public notice is on file with and available for inspection at the newspaper responsible for publishing the instrument as legal notice. The memorandum addresses the character of the Internal Revenue Service and other agencies of the Department of the Treasury, and the legal application of the Internal Revenue Code. Part 1. IRS Identity and Principle of Interest. In 1953, the Internal Revenue Service was created by the stroke of a pen when the Secretary of the Treasury changed the name of the Bureau of Internal Revenue. Bracket T.O. number 150-29, G.M. Humphrey, Secretary of the Treasury, July 9th, 1953. Bracket. However, no congressional or presidential authorization for making this change has been located, so the source of authority had to originate elsewhere. Research to which IRS officials have acquiesced suggests that the Secretary exercised his authority as trustee of Puerto Rico, trust number 62, bracket, Internal Revenue, bracket C, 31 U.S.C. 1321, bracket. And as will be demonstrated, the Secretary does, in fact, operate as Secretary of the Treasury, Puerto Rico. The solid link between the Internal Revenue Service and the Department of the Treasury, Puerto Rico, was first published in the September 1995 issue of Veritas magazine, based on research by William Cooper and Wayne Benson, both of Arizona. In October, a criminal complaint was filed in the office of W.A. Drew Edmondson, Attorney General for Oklahoma, against an Enid-based revenue officer. And in the time since, IRS principals have failed to refute the allegation that IRS is an agency of the Department of Treasury, Puerto Rico. In November, criminal complaints were filed simultaneously with the grand jury for the United States District Court for the District of Northern Oklahoma, Tulsa, and the Office of Attorney General, Edmondson, and both of the Office of the United States Attorney and IRS principals have yet to rebut the allegations in that instance. Bracket, capital letter United States of America, verse Kenny F. Moore, and all others, 95 CR-129 C, bracket. So here within the bracket, the name United States of America. So all the letters of United States of America, the name, every single letter is capitalized, capital letter. By consulting the index for Chapter 3, Title 31 of the United States Code, one finds that IRS and the Bureau of Alcohol, Tobacco, and Firearms are not listed as agencies of the United States Department of the Treasury. The fact that Congress never created a, quote, Bureau of Internal Revenue, quote, is confirmed by publication in the Federal Register at 36 FR 849-890, bracket C.B.1971-1, 698, bracket, 36F.R.11946, bracket C.B.1971-2, 577, bracket, and 37F.R.489-490, and in Internal Revenue Manual 1100 at 1111.2. Implications are condemning both the IRS and third parties who knowingly participate in IRS-initiated scams. No legitimate authority resides in or emanates from an office which was not legitimately created and or ordained either by state or national constitutions or by legislative enactment. See variously United States versus Germain, 99 U.S. 508, 1879. Norton versus Shelby County, 118 U.S. 425, 441,6S.CT.1121 bracket 1866 bracket etc. Dating to Pope vs. Commissioner, 138 F.2D 1006, 1009, 6th Circuit, 1943. Where the state is concerned, the most recent corresponding decision was State vs. Pinckney 276 N.W.2D 433, 436 bracket Iowa 1979 bracket. Another direct evidence of the fraud is found at 27 CFR 1, which prescribes basic requirements for securing permits under the Federal Alcohol Administration Act. The problem here is that Congress promulgated the Act in 1935. And the same year, the United States Supreme Court declared the Act unconstitutional. Administration of the Act was subsequently moved offshore to Puerto Rico. Along with the Federal Alcohol Administration, an operation eventually merged with the Bureau of Internal Revenue Puerto Rico, which until 1938, along with the Bureau of Internal Revenue Philippines, created by the Philippines Provisional Government via Philippines Trust Number 2, which is also called Internal Revenue. See 31 U.S.C. 1321 for a listing of Philippines Trust Number 2, bracket Internal Revenue, bracket, administered the China Trade Act, bracket, licensing and revenue collection relating to opium, cocaine, and citric wines, bracket. This line will be resumed after examining additional evidences concerning IRS and Commissioner of Internal Revenue Authority. Further verification that IRS does not have lawful authority in the several states is found in a parallel table of authorities and rules beginning on page 751 of the 1995 Index Volume to the Code of Federal Regulations. It will be found that there are no regulations supportive of 26 U.S.C. 7621, 7801, 7802, and 7803. Bracket. These statute listings are absent from the table. Bracket. In other words, no regulations have been published in the Federal Register extending authority to the several states and the population at large. 1. To establish revenue districts within the several states. 2. Extending authority of the Department of the Treasury Puerto Rico to the several states. 3. Giving authority to the Commissioner of Internal Revenue and assistants within the several states. Or 4. Extending authority of any other Department of Treasury personnel to the several states. Authority of the Internal Revenue Service via the Commissioner of Internal Revenue is convoluted in regulations, but makes an amount of sense by citing various regulations pertaining to the service and the application of the Commissioner's authority. General Procedural Rules at 26 CFR 601.101 bracket A bracket provide a beginning point. Number A, point A. General. The Internal Revenue Service is a bureau of the Department of the Treasury under the immediate direction of the Commissioner of Internal Revenue. The Commissioner has general superintendence of the assessment and collection of all taxes imposed by any law providing internal revenue. The Internal Revenue Service is the agency by which these functions are performed. The fact that there are no regulations extending Commissioner of Internal Revenue or the Department of Treasury authority to the several states. Bracket 26 USC 7802 bracket A small a bracket has greater clarity in the light of the general merging of functions between IRS and other agencies presently attached to the Department of the Treasury. The Commissioner is given responsibility for issuing rules and regulations for the Code at 26 CFR 301.7805-1. With approval of the Secretary, but there are no sites of authority for the CFR subpart. Whether Treasury order, publication in the Federal Register, or even statute side. In other words, there is no actual or effective delegation which vests the Commissioner with significant independent authority which might be conveyed to IRS, BATF, Customs, or any other department of the Treasury agency with respect to powers extending to or affecting the several states and the population at large. Point 2. Federal Alcohol Administration. The Federal Alcohol Administration, the offices of the members thereof, and the office of the administrator are abolished, and their functions shall be administered under the direction and supervision of the Secretary of the Treasury through the Bureau of Internal Revenue in the Department of the Treasury. Again, the Federal Alcohol Administration Act of 1935 was declared unconstitutional in 1935, and the operation thereafter transferred offshore to Puerto Rico. The name of the Bureau of Internal Revenue was changed to the Internal Revenue Service in 1953. Then, the Bureau of Alcohol, Tobacco, and Firearms, a division of the Internal Revenue Service, was seemingly separated from IRS. In relevant part, the order reads as follows. Number 1. The purpose of this order is to transfer, as specified herein, the functions, powers, and duties of the Internal Revenue Service arising under law relating to alcohol, tobacco, firearms, and explosives, including the Alcohol, Tobacco, and Firearms Division of the Internal Revenue Service, to the Bureau of Alcohol, Tobacco, and Firearms herein, after referred to as the Bureau, which is hereby established. The Bureau shall be headed by the Director of the Alcohol, Tobacco, and Firearms herein referred to as the Director. Number 2. The Director shall perform the functions, exercise the powers, and carry out the duties of the Secretary, and the administration and the enforcement of the following provisions of law. Number A, capital A. Chapters 51 and 52 and 53 of the Internal Revenue Code of 1954 and sections 7652 and 7653 of such code in so far as they relate to the commodity subject to tax under such chapters. Capital B, number B, okay. Chapter 61 to 80, inclusive to the Internal Revenue Code of 1954, insofar as they relate to activities administered and enforced with respect to chapters 51, 52, 53. Transfer of functions and duties of IRS to BATF relative to Internal Revenue Code, subtitle capital F, is important where the instant matter is concerned, as the only regulations published in the Federal Register applicable to the several states are under 27 CFR, Part 70, and other parts of this title relating exclusively to alcohol, tobacco, and firearms matters. However, it doesn't end there. In Reorganization Plan Number 1 of 1965, bracket 5 USC 903, bracket, the original Bureau of Customs, created by Act of Congress in 1895, was abolished and merged under the Secretary of the Treasury. In a Treasury order published in the Federal Register of December 15, 1976, the Secretary of the Treasury used something of a sleight of hand to confuse matters more by determining, quote, the term Director, Alcohol, Tobacco, and Firearms has been replaced with the term Internal Revenue Service. Okay, I'm going to read it again, this paragraph. In a Treasury order published in the Federal Register of December 15, 1976, the Secretary of the Treasury used something of a sleight of a hand to confuse matters more by determining, quote, the term director, alcohol, tobacco, and firearms has been replaced with the term Internal Revenue Service, quote. Wow, this is shocking. Obviously, it is impossible to replace a person with a thing when it comes to administrative responsibility. However, the order demonstrates that IRS and BATF are one and the same, merely operating with interchangeable heads. Therefore, definitions and designations applicable to one are applicable to the other. In definitions at 27 CFR 250.11, the following provisions are found. Revenue agent and any duly authorized Commonwealth's Internal Revenue Agent of the Department of the Treasury of Puerto Rico. Secretary, the Secretary of the Treasury of Puerto Rico. Secretary or his delegate. The Secretary or any officer or employee of the Department of the Treasury of Puerto Rico, duly authorized by the Secretary to perform the function mentioned or described in this part. In the absence of any other definition describing revenue officers and agents, the Secretary or the Department of Treasury. Definitions above are uniformly applicable to all IRS and BATF departments, functions, and personnel. In fact, it will be found that even petroleum tax prescribed in subtitle D, capital D, of the Internal Revenue Code applies only to the United States territorial jurisdiction, exclusive of the several states, and to imported petroleum. BATF has authority only with respect to firearms, munitions, etc., produced outside the several states and the first sale of imports. The two delegations of authority to the Commissioner of Internal Revenue are thus far located tend to reinforce conclusions set out above. Treasury Department Order Number 150-42, dated July 27, 1956, appearing in at 21 Fed Regulation 5852, specifies the following. The Commissioner shall, to the extent of the authority vested in him, provide for the administration of United States Internal Revenue laws in the Panama Canal Zone, Puerto Rico, and the Virgin Islands. On February 27, 1986, bracket 51 Fed Regulation 9571, bracket Treasury Department Order Number 150-01, specify the following. The Commissioner shall, to the extent of the authority otherwise vested in him, provide for the administration of the United States internal revenue laws in the U.S. territories and insular possessions and other authorized areas of the world. To date, only 3 statutes in the Internal Revenue Code 1986, as currently amended, have been located that specifically reference the several states, exclusive of the federal states, bracket, District of Columbia, Puerto Rico, Guam, the Virgin Islands, etc. bracket 26 U.S.C. 5272 bracket small b bracket 5362 bracket small c bracket and 7462. The first two provide certain exemptions to bond and import tax requirements relating to imported distilled spirits for governments of the several states and their respective political subdivisions. And the last provides that reports published by the United States Tax Court will constitute evidence of the reports in courts of the United States and the several states. None of the 3 statutes extend assessment or collections authority for IRS or BATF within the several states. IRS is contracted to provide collection services for the Agency for International Development, and case law demonstrates that the true principles of interest are the International Monetary Fund and the World Bank, bracket, Bank of the United States versus Planters Bank of Georgia, 6 L.ed, Wheat, 244, U.S. vs. Burr, 309 U.S. 242. Also, see 22 U.S.C.A. 286. E.T. S.E.Q. In other words, IRS seemingly provides collection services for undisclosed foreign principals, rather than collecting internal revenue for the benefit of the constitutional United States government operation. Okay, I'm going to read this sentence again. So based on above case laws and findings, IRS seemingly provides collection services for undisclosed foreign principals, rather than collecting internal revenue for the benefit of constitutional United States government operation. Wow. To date, IRS principals have failed to dispute the published Cooper-Bentson allegation that the agency, via these foreign principals, funded the enormous tank and military truck factory on the Kama River, Russia. The Internal Revenue Service, a foreign entity with respect to the several states, is not registered to do business in the several states. So Internal Revenue Service is totally a foreign entity, not a U.S. federal agency, not a U.S. government agency.